Well, good afternoon, and we've just spent the last 20 minutes having some debates and arguments about what we're about to talk about, so it could get a little bit lively. Tamsin, thanks for joining us.
Thank you very much.
Lewis, thank you for being here.
Thank you for having me.
So we'll have some fun. I might just start off by saying that we're going to try and run the first hour through the content. We'll try and leave the back half hour for Q&A. For all those people who wanted to get their questions in early, thank you. We have an absolute laundry list of questions, some of which we can ask and some of which are perhaps a little bit provocative and we might leave for another day. But so we'll try and do it that way with half an hour at the back end. I'm not sure if we'll finish in time for the half hour, but we'll see how we go.
And you can keep to ask questions.
Oh, please ask questions as we go. I've got the iPad with me as well. And as always, we'll sift through that and see which ones are probably going to be helpful to the audience. Now, I'm a little older than Tamsin and Lewis, so I can probably say this. The bill that's gone into Parliament represents, in my mind, the largest workplace relations reform since 1993. And you've probably just seen that I've suggested that it's a much bigger reform than the work choices reform, and I actually do believe that. Work choices in many ways still stuck to the broad architecture that Keating and co brought in the early 90s, whereas this reform dramatically changes that architecture. So there'll be a lot to talk about today, and we've got some shared views about some of it, and we've got some slightly conflicting views about others, but we might share that as we go. So we've got quite a bit to move through, and this is broadly our agenda. We thought we'd start with bargaining because, surprisingly, bargaining's ended up being probably the biggest part of this, probably more than we didn't expect that, but it ended up being it. And most of the bargaining stuff is all around this notion of multi-employer bargaining, which we'll talk at length about. We're going to get a little bit into some changes around the Better Off Overall test and also enterprise agreement approvals, a little bit about enterprise agreement terminations, talk a little bit about industrial action, and as part of that we'll talk about the introduction of arbitration to resolve bargaining disputes. Quite a bit to talk about around the sexual harassment and upcoming respect at work reforms. And Tamsin, you've kind of led that debate now on the employer's behalf, probably since before you joined us back when you were with the Australian Chamber.
Yes, yeah.
So I'm going to lean on your expertise around that more than mine. Big changes around flexible work requests and the introduction of arbitration. And then we'll come down the back end, fixed term contracting, a little bit about gender equity reforms. We'll debate who's going to do that when we get to it. And then there's just a few little bits at the back end, which probably aren't particularly dramatic. They're already out there in the media around the Australian Building Commission and others. So that's broadly the agenda we want to take. So we'll take a deep breath and we'll crack into it. Let's start with bargaining. I want to just set this out because we've been talking about this now for about 3 weeks and we've kind of got our head around it. But if you haven't, then there might be a struggle. In many respects, what we're going to see in this bill is three new streams, although they're not entirely new. That's probably the best way to say it, Lewis, I would think. They're sort of, some of them are derivatives of pre-existing streams. So we still have a system which allows for bargaining at a effectively single workplace, but the legislation introduces the notion of multi-employer bargaining in what I've called general industry. And you'll hear this phrase single interest bargaining or single interest authorisation. It's a strange phrase to use, but read multi-employer bargaining when we talk about that. And then you've got this particular bargaining stream for what's called supported industry. So I think aged care, childcare, industries which are effectively Commonwealth or state government funded. And then we've got this other stream, which is effectively the consensual stream. So there's really 4 streams in here, and it's a bit complicated how certainly the first 2 relate, but we're going to take you through them step by step. And I'm going to concentrate first of all on that multi-employer bargaining one, which is the single interest authorisation, single interest agreement one. And bear with, there's a little bit of content on the slides because some of it might be relevant to the viewers. Lewis, how do you get into it? How do you get into it? What happens when you're in it? And how do you get a vote up? Take us through from start to finish.
I think the answer is just run. So this concept of single interest authorisation, what enables is a bargaining representative. It's most likely
Call it
going
a union.
yeah.
Call it a union.
I was going to say most likely to be a union. It doesn't technically need to be, but you're going to have a union that can apply for this authorisation. And what the authorisation effectively does is it allows them to bargain with multiple employers in relation to a single agreement, and it enables, once that bargaining stream is up and running, all the other things that come with bargaining to kick in relation to those multiple employers. So industrial action, so arbitration that we're going to come to. All of these elements that attract or that are currently attached to enterprise bargaining can apply to multiple employers simultaneously in relation to one agreement. And to get in, there are some prerequisites that the bill identifies.
So the union's made the application for this authorisation.
That's
What
right.
does it have to prove when it gets there?
Yeah, so it needs to demonstrate to the Commission that the group of employers it has banded together have what the bill calls clearly identifiable common interests. I'll come back to that phrase, but that's the first element. It needs to demonstrate that the group of employees that are chosen have been fairly chosen. It needs to demonstrate that at least some of the employees are represented by a union, so we're definitely having unions in here. It also critically needs to show the majority of employees of the relevant employers want to bargain for the EA. That's a very interesting phrase, the majority of employees of the relevant employers. What that on a current drafting looks like is you don't need to show a majority of employees in each business. Rather, what you need to show is a majority of the global group.
So if I've got 5 employers in my group, I'm the union. Call me the Transport Workers Union.
Yes.
I've got 5 employers. I've got one employer who's got 10,000 people, and the other employers have 500. It's a vote of the 14,000 collectively, and that one employer, if all of the employees of that employer voted to bargain together, that could win the vote.
For the whole group of the employers.
Now, that's just to start bargaining, right?
That's to start bargaining. And so we need to be careful here because the Minister Burke has announced yesterday that they're likely looking to amend some of these provisions, but it's not yet clear how they're going to amend it. Are they going to change the rules as to who votes on what to start bargaining, or are they only changing the rules when it comes to the approval of the agreement at the end of the bargaining session? And we don't know the answer to that question.
So at the moment,
yet.
all the employers are in the pot. We have a vote of all the employees, and it's the majority of the employees
of the global whole.
The global whole.
And that is the current.
Your people might actually vote no. We don't want to be a part of this, and
they're still pulled in.
You get scooped in.
And that's the current drafting. And there also is an element that it's not contrary to the public interest.
Tough test
to make the authorisation. Public interest is notoriously quite a high bar. I want to come back to this clearly identifiable common interest. What the test doesn't say is the employers need to holistically have a common interest. Now, that would be quite a high hurdle. You need to be engaged in some common enterprise, or you need to have some, when you assess both businesses together, there is some overarching commonality in their businesses or undertaking. That's not the test. The test is clearly identifiable common interests. And what that tends to suggest is you could identify just a couple of things in common, and that might be sufficient.
Same industry, same geography, same customer base.
Any of them, you get 2 of them and you're probably well on your way to clearly identifiable common interests.
Yeah. So what about all of the businesses in a shopping centre?
Again, you're all in the same...
That sounds good to me.
You're all in, no matter what they're doing.
Arguably, when you look at the examples that are in the legislation at the moment, they are the types of things that could generate a clearly identifiable common interest. And so it may be that the hurdle is not high in that regard.
So it's really interesting because it's not that my defence is to prove I have antagonism to these other people. It's just that the union has to prove there is a common interest.
That there is some level of common interest
in some space. So we could all be heavily competitive with each other, but that doesn't matter.
So it doesn't talk about competition. It doesn't appear that the legislation requires regard to the fact that you might be competitive.
But the presumption probably is that you are.
You may be.
Yeah. Okay.
And so that's an overarching level, the test that needs to be satisfied.
So let's say you get that authorisation.
Then you're into
bargaining.
Multi-bargaining. That's right. And so what happens then? You've got good faith bargaining obligations that apply. That means you need to meet at reasonable times, hand over information. That means all the protected industrial action rules now apply. And if you can't reach agreement, as we'll see later on, you can have arbitration. So once you're in this stream, it is actually very difficult to leave.
So this would be a negotiation very similar to the negotiations I would have done in the 80s and 90s for whole industries, where I was sitting at the table acting for the 7 or 8 major players in the industry. The union occasionally was trying to break one of those away to try and get some leverage. I was trying to hold them together to have a common position. Sometimes there'd be somebody else other than me acting for 2 of them, and the union would be playing. So we're going back to the good old days.
I don't know if we call them the good old days, Nigel, but we're going back to a much broader industry-based bargaining system. Yes.
Right. Okay. So let's say the negotiations have carried on.
Yes.
How do we get it to an agreement, or how do we not get to an agreement? What happens then?
So there comes a point at which, if the employers have reached a point that they want to put an agreement to their workforce, and then we'll come to what happens if the employers disagree. But let's just say at least some employees.
There's 5 employers in the pot. We're all comfortable with the agreement. We put it to our workforce.
They put it to the workforce. Now, again, at the moment, the drafting says that you don't need a majority of each workforce for it to be approved, just a majority of the whole. This is the thing we expect to change. Minister Burke has signalled that probably what's going to be required is a majority of employees in each business. And so what that would mean, presumably, is that if 3 of the businesses the employees voted up, an EA is made for those 3, but for 2 that voted down, an EA is not made, and they're still bargaining.
Okay.
And that's what we expect based on some of the public comments that Burke made last night and today.
So if you think about the way that game works, a union could be very selective in picking 2 or 3 highly unionised companies that it's got relationships with to try and drive the outcome.
Yes.
Or it possibly might be very brave and pick an entire sort of industry of sort of key players, even though it might be far more contested and difficult. So it could be played out in many different ways.
That's right. And the reality is, if you don't reach agreement, you're still in this world of bargaining. So then you still have good faith bargaining. You still have the prospect of arbitration. And so you may end up with an agreement in the end, which doesn't look too different to the one that got up. The other thing we need to be very careful about here is in the second reading speech, when Minister Burke introduced this legislation, he flagged that the government is considering only allowing employers go to the vote if the union agrees that the EA goes to the vote. Now, if that comes in, that's a major change. So what that would be is the employers don't even have the right to actually put this to their workforce. What they need is the union sign-off to even put the agreement to the workforce. So we're moving away from employers agreeing on an enterprise agreement with employees and moving to a much more union-led approach if the changes that Minister Burke flagged are made.
So this is really, excuse me, reflective of the old days where you were basically doing a deal with the union that would then be endorsed by the employees, as opposed to bargaining to an outcome that's voted up by employees, which is what we have today.
That's right.
Okay. So that's
Stream one.
Stream 1. And as we said, arbitration might be available if there is no deal for some or all, and we'll come to arbitration later. Industrial action applies in the normal way. Is the industrial action, Lewis, company by company?
Yes. So the idea, as we understand it, is that it's going to be you would need each respective workforce to approve of the industrial action for it to occur in their.
But they could just line it all up, right? So they're all doing the same type of industrial action at the same time.
Absolutely.
Yeah.
And that's how you end up with industry-wide industrial action.
De facto industry-wide.
Right.
Even though they said there wouldn't be any industry-wide, the system allows for it if it's cleverly done.
Yes.
Yeah. So that's stream 1.
Yes.
Okay.
There's some exceptions here. It's not available for small business employers. That's a small carve-out, because small business employers is employers with 14 employees or less by way of headcount. So there's a small grouping that are carved out. And importantly, the other really big carve-out is if you have an enterprise agreement that is in term, that is, it hasn't reached its nominal expiry date, then you can't be hauled into this multi-employer bargaining. Now, again, there's been a change flag to this, which is because there's a concern about what happens if my agreement expires and then the very next day, does that mean I can be hauled into this multi-employer stream? the government's announced it's going to provide some grace period, if I can call it that. I think that's the phrase that was used by the government, to allow employers to bargain before then potentially being hauled back into this multi-stream. So you do have a period of immunity, which is during the life of your EA and before its nominal expiry, plus potentially a grace period that's been flagged, but we're yet to see how that grace period is put into play.
This will be a common theme because the primary defence about being dragged into an industry arrangement is going to be you have your own agreement and it's still in its nominal life.
That's right.
And all of a sudden, that in this scheme becomes a pivotal strategic issue, whereas before you might have had a cultural decision about leaving your agreement to expire. You didn't actually have a cultural reason to renegotiate it. This idea of having an agreement that's current is now a strategic fundamental consideration. And I think I've been talking to clients in the last 3 or 4 days, that's been the nature of the conversation about renegotiating or hurriedly finishing negotiations so that I'm kind of preserved for the next 3 or 4 years out of this.
And one of the key considerations now will be, how do your EAs align with competitors' EAs in terms of timing? Because what you may want is a staggering of expiry dates and things like that if you're trying to insulate yourself. And so I think what businesses need to start thinking about strategically is not just how does my EA sit with other EAs in my business, which some of our clients already look at.
Factory A versus Factory B.
But now, how does my EA align with other key players in the industry that sit in my geographic area or do similar things to what I do? And am I aligned in terms of timing with them, which might not be a good thing, or am I quite staggered? And that's going to be a key consideration for business moving forward as well.
Unions like the Transport Workers Union have been working for the last 3 or 4 years to try and align all of the expiry of most of the major players in, say, that industry, possibly in preparation for this, quite fortuitously. I'm just going to take a couple of questions if we can, rather than wait till the end, Lou, if you don't mind. What happens if these employer enterprise agreements in place? We've just answered that. But it's about them being current rather than expired. That's really the issue. And somebody's just said, could everybody in an entire sector band together, arguing that they have a common interest? And I suspect that more likely than not, the answer is yes.
Yeah, the determination of this common interest test in the first few cases is going to be really important. But I think the way the test is currently worded seems to be quite a large window through which to ram people together.
Yeah, absolutely. So that's stream one.
Yes. So
let's just talk about...
this is roping in.
We're going to go to roping in. Oh,
yes.
Lewis has moved the slides around for us. Can I? Because I'm really.
Yep.
Is the word aggrieved the right word to use?
Yeah. No. You lead us off.
If you think the bargaining bit's challenging, it's not. It's this bit. All right. So let's assume that we'll just do this in your general sector, although this applies to the supported stream as well. So let's just say that there's now an industry transport agreement that's been negotiated by, say, 3 major transport companies in the TW. It's been approved by the Commission. And I'm the TWU. I shouldn't pick on the TWU too much today, but let's say I'm the TWU. I don't really want to have to bargain with anybody else. I just want people to be on that industry agreement. That's what I want. There are provisions in the Act, which is in section 216. It's in my brain every time I go to bed at night at the moment, which basically allow this to happen. The union goes and sees your employees and says, would you like this agreement? Would you like these conditions? Possibly saying, would you like a 20% wage increase? And they say, well, that sounds pretty good to me. Organises a vote, gets 50% plus 1 to vote yes. They make an application to the Fair Work Commission to have the employer added in as being covered by the industry enterprise agreement. Notice the employer's not been involved in bargaining at all. That doesn't matter. You're just roped in. Now, Lewis, when I get there, what are my defences?
Well, firstly, a majority of your employees need to
Let's say
agree.
they did.
So that's the first thing. If the majority of the employees have agreed to be roped in, you've got limited defences. The first is to show you don't have clearly identifiable common interests with the other businesses that are already on the EA. The second is to say that the group of employees being added is actually something that's going to be contrary to the public interest. Now, that is a very high hurdle again.
High hurdle.
So that's going to be very difficult. And the only other thing that needs to be taken into account is the views of the people already covered by the EA. And I'm not sure whether the persons already covered are probably not going to be too vested one way or another, because they're not being roped in, they're already in. So it's very limited circumstances or very limited triggers to try and stop this roping in from occurring. The primary defence is to try and run this common interest point to say, I don't have clearly identifiable common interests. Of course, the other thing is I've got an EA in its term. So that's the other defence. I've got a nominal
If
EA
I'm a small
in its
business,
term.
I'm exempted as well.
Small businesses are exempted.
Yeah, as
less
well.
than
But
15.
the views of your business, the way you operate, the competitive nature of you, maybe with the people in that, all don't matter.
You'd have to try and do as much as you can with all the matters that Tams has just raised and ram them through some common interest argument to try and say this isn't something that is
So this is I've made an industry agreement. It might be with it might be with two major companies in the industry, and then what I'm going to do is I'm just going to try and rope everybody else in to be forced into that by getting their employees to vote. They want a piece of it.
Yes.
So earlier when you mentioned there were 5 and say 2 dropped off, they didn't want to agree. Can they just be scooped up later?
So this is a really fascinating part of it. So they were in the multi-bargaining to begin with.
My answer is yes.
Yeah. I think the
Yes.
short answer is yes.
Yeah.
Right.
And so you could have a world where just because you don't reach agreement, that agreement comes back to haunt you.
So maybe it's better to just
4
stay
weeks
a part of
later.
the negotiation and try and, okay. It's interesting.
We've just got to ask the question, what if there's large pay discrepancies? Well, my answer is too bad. I think this is being designed to try and lift people up to a much higher rate of pay. Remember, the Labor Party said they're going to use this to increase pay, so they were pretty honest about that. They were very transparent about that. And I think that this is being done to really try and challenge competition based on labour. That's my sense.
Stop it.
To stop it. To create what some people historically have described as the level playing field. So labour will be, but it'll be a much more costly level playing field. So that will be the way we'd look at it.
So do you see them coming together with big groups of employers to make a single interest agreement, or do you think they'll just find the two and then just...
I think it will vary. I think in some industries they will definitely go with just 2 and they'll find the weaker links, so to speak. They'll make their EA, and then a bit like the CFMU, how it operates in building construction, add employer by employer. But I think you will find in some other industries, aviation's a good example, where there's a lot of animosity towards Qantas and the way it operates. I think you'll find that they try and loop everyone in together and have one grand deal. So I think it'll depend on the industry.
Yeah. Now, think about what we just said, and then think there is actually now a supported bargaining stream. I want you to think about those employers, those industries which are Commonwealth or federally funded directly or indirectly. And we obviously have a very large interest in the childcare sector, in the aged care sector and others. So we're very familiar with these industries. They have their own version of what we've just described. It's very similar, some slight nuances though, which we might let's take you through. So instead of the single interest authorisation, you have to get what's called a supported bargaining authorisation in this area. It's a slightly different test. There is still that notion of identifiable common interest. Relevantly, one of the things that's identified as something you have regard to in establishing identifiable common interest is, quote, being substantially funded directly or indirectly by the Commonwealth, a state or a territory. So I would suggest that it's going to be difficult to argue you don't have an identifiable common interest. And also the Commission has regard to the prevailing pay and conditions in the relevant industry or the sector under consideration. So there is that authorisation process. And again, as we've already said, that might be an authorisation involving a union and a small number of people or a large number of people. We still have to have that vote process from the employees involved to bring them into that process. So very, very similar, but slightly different nuance in the actual test to get the authorisation. And then we're in the same process that we've already talked about. We're in bargaining. As we've already said, there might be a deal, there might not be a deal. There might be a deal for some, others might fall off. We have arbitration, we have good faith bargaining. We have all of those rules kicking in. So it's a very, very, very similar situation to the stream that we've already talked about, although specifically for the supported stream, the funded stream.
And the only one of the key differences, though, will be that you can't enter into an EA to insulate yourself from these changes. So if you have an EA, so be it. But if you intentionally enter into an EA just to get around these provisions, that does not insulate you from the supported bargaining stream, and you can still be caught up in it.
And Lewis is right. There's this kind of if you're just creating an enterprise agreement to try and avoid this, there's express provisions which allow that to be ignored. Again, though, if you do have an enterprise agreement and in its term, that's a defence.
That'll be a defence.
As long as it's a bona fide enterprise agreement, that would be a defence.
And the small business defence?
There's no small business defence here at all. Okay, so the notion of excluding small business is gone in the supported sector. It's at large. There's no small business. We had a long talk about that this morning.
Well, there appears to be a slightly different policy reasoning behind each of them, which is this is all about lifting wages in what the government has identified as lower paid sectors. And so I think that it's more of an industry-wide approach whereby they want to elevate the whole industry in terms of wages, whereas the single interest stream we've earlier discussed is more about convenience of bargaining in industry. This is a deliberate attempt to inflate wages across the industry.
And a bit like we just talked about, the same roping in concept applies. So you might not have been a part of that industry negotiation, but if the union can get your people to vote 50% plus one to go into it, they can make an application to have you join to it, even though you've not actually been involved in bargaining. And on this occasion, the Commission just has to decide that it's appropriate for the employees to be covered by the agreement, which is a very wide discretionary question, and it's aimed at the appropriateness for the employees. It's not actually aimed at challenges and issues for the employer. So it's good that, again, first case off the ranks is going to be a really important case. So just understand that very similar scheme of arrangement for the supported sector. And again, many of the things we've talked about already could apply here. You could be in a particular part of the supported sector. A union could actually cut a deal with one or two very large, couple of very large operators, and then there could be a process to try and rope everybody else into that arrangement. So it's not just being dragged into industry bargaining that's the challenge. It's being roped into it afterwards that might be the challenge. And obviously the various sectors at the moment have very little visibility around funding and support for these things. At the moment, these things are entirely separate to any funding conversations that may not occur with government or be occurring as we speak. So just understand that the supported sector has its own version of all this, and it's probably easier for the union than the other version, even though it's hard to think there could be an easier version. It's probably the easier version.
I think we've
covered all of that. You can take industrial action and the like. There is this kind of weird and funky third stream, which is this voluntary or cooperative stream. We're all shaking our heads.
I just don't know who's going to use it.
It would be wrong for me to explain which small business group lobbied for this, but there was a small business group that lobbied for it. Basically, what this is this sits separately to all the others.
Yep.
You can't take industrial action under this stream. And I would probably think of it this way. Imagine an employer association and a union reaching an agreement for a template agreement that might be relevant to their industry or their membership. Mm-hmm. They get that template agreement approved, and then you have this process employer by employer about voting to join up to it, and consensually the employer and their employees join up to it. You could kind of see it there. This is entirely voluntary.
There's no authorisation, is that right?
No. But because it's a voluntary process, effectively you can rope in. You have an existing multi-enterprise agreement, and you can just say, well, we would like that to apply to us, provided majority of the employees agree, provided the employer wants it. There's no more boot tests. There's no more usual bargaining process. You skip all the bargaining, and you just apply the agreement to your business. But
importantly, it's voluntary opt-in between you and your employees.
That's right.
It's not being roped in forcibly.
Yeah.
So it's there. Really, you're struggling to see. You can't see anybody using it.
I don't, but open to being surprised.
Some people have described this as the stream for small business. Again, we'll have to wait and see because the boot still applies.
Well, it still applies to the original
template.
Yes,
So it still applies. So we're not really sure how much mileage this one will get, but we'll just wait and see. We should just cover this because this is a bit of a change, Lou. So there's two, and one of them's big, right? So let's say that I'm just going to bargain in the way we've always done. It's just my company and my people. Let's just talk about if you've never bargained before, bargaining's initiated effectively the same way. That is, I can initiate it myself. We can agree to bargain,
or you get a majority
support determination of my employees.
That's right. Yeah.
So, as in the old days, if I was resisting bargaining at my workplace, and let's say the union or a bargaining representative could get 50% plus one of my people to sign a petition to say you should bargain, that still applies.
Yep.
All right. I've got an agreement. I've had an agreement 3 or 4 versions, and it's expired.
Yes. So now, the change here is
that's a big change.
That effectively, currently, if employees want to compel an employer to bargain, they again require a majority of the employees to support initiating bargaining. They need to demonstrate that to compel an employer to bargain. That has been removed under the bill, and what now applies is that if you have an EA that has expired any time in the last 5 years, a bargaining representative that was involved in the last round of the EA negotiations can simply request that bargaining begins, and that will kick off a new round of bargaining. So again, you're into good faith bargaining obligations, you're into industrial action and possible arbitration. So that's a bit of a change as well, which is going to make it easier to recommence bargaining where there are existing EAs. And what it does for businesses that enter into EAs for this first time, you're really locking yourself in. It's going to be very hard to leave a regulatory world of being subject to an enterprise agreement.
You're on the hamster wheel. Get
once you've got it.
You're on the hamster wheel. And this is actually a strategic issue for me because if you think about it, some enterprise agreements that have been made say the employer must renegotiate. We've talked to clients a lot about those clauses and the utility, sometimes good, sometimes bad. A lot of enterprise agreements don't say anything about renegotiation, and some employers will say, look, culturally, back then I had to, but culturally I don't need to anymore, and I can probably just now work out how I pay people and leave the EA where it is. If a union happened to be covered by that agreement, let's say it had 10 members and it was previously covered as a bargaining rep, it could just simply write to you now saying, we want to renegotiate, and guess what? You're obliged to.
Or even just one disgruntled employee, right?
Or
bargaining
I think, no, you need to have been a bargaining representative for the previous agreement.
For the previous agreement. So
that could easily be another employee.
It could be another employee who's a bargaining rep.
Yeah.
And now, of course, remember, if you don't want to get involved in industry bargaining, having a current agreement if there's offence, all of a sudden, strategically, you might have left an agreement sitting there for quite a while, it expired. You might all of a sudden be saying, gosh, I want to get that agreement renegotiated and lock it in so I am immune to being dragged into this industry bargaining world. So that is a really important strategic consideration.
We're going to have to, we've spent a lot of time on bargaining, but it is the biggest, so we'll keep
How much is changing in the boot list?
A lot. I think, look, I'm happy to deal with boot and EA privilege, deal with it quite quickly because we've got a lot of content. So I think in relation to the boot, there's 2 changes. One is that they are making it easier to have the better off overall test applied. There's no doubt they've removed a lot of the pain points. Employees will now be assessed globally against the award, not on a line-by-line basis. The government's proposing to remove any test of looking at prospective employees, and the Commission's only required to look at patterns of work that are reasonably foreseeable. So a lot of progress there, that the boot test will be easier to apply when it's first conducted. The concern is, unfortunately, that in exchange for an easier boot test on the next slide, what we'll see is that the Commission has introduced a reconsideration of the boot that will kick in. And how this operates is that if a pattern of work effectively is changed from when it was first considered, when the agreement was lodged, for either an employee or a class of employees, I think the language used is the agreed pattern of work or hours of work, there's any change to that, then at any point an employee or bargaining representative can apply for the boot to be redone, reconsidered, to understand whether under the new pattern of work, the EA is still better off overall compared to the award. So what that effectively means is that once an EA is approved, its terms are not locked in for the nominal term for the 3 or 4 years, but rather its terms can constantly be reviewed throughout the life of the agreement. And if the commission is not satisfied that the EA later on is better off than the award because some patterns of work have changed, etc., then the employer has only 2 choices. It can give an undertaking to address the commission's concern, or the commission will itself vary the EA to lift the terms and conditions as it deems appropriate. And so I think what we're really seeing is a level of uncertainty being introduced. EAs, one of the benefits of EAs was it locked away terms for the life of the EA. Now they are not necessarily locked away, particularly where you're sailing close to the line.
Close to the award. So I read this way: the boot really hasn't materially changed. Some of the silliness around the boot's gone, but the boot itself is pretty much alive and well in its real form. And what we've got for removing the silliness in this bill is this notion that it can be reopened and reconsidered for particular classes of employees on an ongoing basis. Yep. Which is a pretty poor trade-off, I suspect. It's a pretty poor trade-off. But that's what's happened with the boot.
Yeah. So if you were to restructure and just do different patterns of hours, you basically are automatically going to open this up.
Well, you probably need to come to us and say, if I've got an agreement that's close to the award, you probably need to come and say, if I do this, could this create a reopening?
Will someone be open?
Yeah, that's probably what you have to do. The approval.
I think we deal with this very briefly. There was a number of pain points throughout the last 9 or 10 years in relation to employers not exactly complying with certain requirements in terms of when they issued agreements for vote. Did they give a certain number of days correct notice at the time of the vote, or did they hand out the EA, or did they correctly explain it? All of the approval requirements are largely going to be removed that are technical in nature. There simply needs to be a majority of employees approved, and for single agreements, a notice of employee representational rights needs to be given to them. But in their place, what the commission will issue is a statement of principles to identify when someone has genuinely agreed or not. So the focus here for employers is nothing to do immediately. Once the statement of principles is determined, and I suspect we'll have a role in influencing that through the commission's usual processes, then you're going to have to ensure you comply with that statement of principles. But let's just wait and see what they say. I think for employers, you just need to know that the currently quite rigid process for getting an EA approved might be changed and lightened or lessened somewhat, but let's just wait and see what the statement of principles says.
And again, this will apply to all streams.
Yes.
Yeah. I just will quickly touch on this, if we can. A lot of debate about terminating enterprise agreements. There's been a lot of debate over the last little while about employers who are locked into massive bargaining disputes filing to terminate an enterprise agreement. A lot of our clients, when they've been forced into that as a kind of last resort, I think the union movement have said that's just a tactic that shouldn't be allowed, although we tend to see it as an absolute last resort. That's all going. I'll talk about zombies in a minute. You get zombies if you don't want. I'm going to give you zombies. You can terminate enterprise agreements going forward by consent.
Yes.
Absent consent, it's very, very limited. It's effectively living in a world where if you don't terminate it, the viability of your business is threatened. There's going to be redundancies. So effectively, only in a circumstance where it's so onerous that it's sort of driving you out of business. Outside of that, it's all over.
Yes.
You're locked in, you're stuck. And of course, the answer in the legislation is, well, that's why you've got arbitration.
Yeah.
Zombie agreements?
They're effectively dying a very quick death.
What is the zombie? What is the zombie?
Oh, it's a pre-Fair Work Act agreement. They're gone. If you've got one, you're probably going to be pushed into one of the new various streams. You'll have an ability, though, to apply to the Commission to keep them alive for a little while longer.
4 years?
Up to 4 years.
Up to 4 years.
But
Don't hold your breath.
Yeah, but I wouldn't expect you'll probably get 4 years unless you've got a very generous former agreement, but then they'll be dead in the water.
And look, we've been working with clients over the last couple of years around quite a few of these. We had a client who had a 1993 agreement. If you do have an old agreement and it's important to you commercially, come and talk to us, because this is going to be an important issue to think through. Industrial action, Lewis.
Yeah, so industrial action, there's two probably big changes. The first is that under the proposed reforms, industrial action can only be taken for 3 months after the PARBO results have been declared. So currently, if a union has started industrial action within the 30 days that you usually get to commence, then you can keep going indefinitely. And equally, an employer can take action in response. The reforms contract this right up so that it can only be taken within 3 months, after which you need a new protected action ballot order, which will obviously introduce an administrative hurdle to getting industrial action going again. There's going to be a break in period because you need your PARBO to be determined. And the other thing is, every time a protected action ballot order, a PARBO, is filed, it triggers a compulsory conciliation process. And so it appears that what the government's trying to do...
Before the vote for the PARBO.
Before the vote is declared, before the outcomes get declared. And so what that really does is you've got a 2 or 3 week period after the PARBO is filed to have a conciliation, and it's forcing parties into conciliation at least once conference, at least ostensibly, before industrial action's taken. And I suppose when you think about limiting industrial action to a 3-month window and triggering conciliations every time a new PARBO is filed, what you're getting is a shift towards trying to push people towards conciliation and arbitration over indefinite industrial action.
And a lot will depend on who conciliates and whether or not they're really interested in trying to help the parties, or whether or not it's kind of perfunctory and upheld it and good luck and off you go. We'll have to wait and see, won't we? Just on the right-hand side, it's a little sleeper in the legislation. 3 days' notice normally to take industrial action. It's been extended to 120 hours for multi-employer bargaining. Yeah,
so it's interesting. It's about equivalent because it's 3 working days for single enterprise agreements. And what they've worked out is working days might be different across the multi-employers. So they've changed to 120 hours, which is about, depending on when it falls, may or may not be similar. So 3 working days could be 5 days, calendar days. 120 working hours fits somewhere around about that same. I don't think there's anything nefarious here. They just worked out that working days is a more difficult test when you've got multiple employers. So they've just gone with hours.
With hours.
Which I think is about 5 days, 120.
It is. Now, I expected arbitration to come up there, but it hasn't come up.
I think it's later, but I think
that's fine. We'll crack on.
Sexual harassment.
We talked enough for a while.
Yeah.
Okay, there you go.
Thanks. Okay, the clicker. Enjoy the show. Sexual harassment is finally being put into the Fair Work Act. What's occurring basically is already mirroring what's there. So currently people can go to the Human Rights Commission, whether at the state level, at the federal level, and they can try and conciliate an outcome. If they can't, then they end up in the federal court. Exactly the same kind of process is now going to occur in the Commission. Think of it almost like what occurs for general protections. So you'll try and conciliate or mediate it at the Fair Work Commission level. If someone wants to make a sexual harassment claim, they can put in an application for that to occur. And if they can't get to agreement, they'll still end up in the federal court. The only slight difference is when they put in that application, we've got the existing Stop Sexual Harassment Order kind of stream that will continue to exist alongside this other one. The intention being that the Stop Sexual Harassment Order is meant to stop ongoing or future behaviour, and the new order that you can get from the Commission if you manage to conciliate or arbitrate an outcome is meant to address or redress former behaviour. And you'll actually be able to apply for both at once, which kind of makes sense. If you still decided to stay in that workplace where you're allegedly being sexually harassed, you could make an order for both at the same time. But really, it's effectively just mirroring the current Human Rights Commission process and chucking in.
One of the questions that's just come through is, can they award costs? Can they award damages?
It's going to be, the costs are going to remain with the parties.
So legal costs with the parties. What about
as it does in the Fair Work Commission?
Like can they
that's if
compensation?
Well, that's if you agree to arbitration at the Fair Work Commission level. If you don't agree to arbitration, you're only conciliating or mediating an outcome. If you go to the federal court, the existing rules still apply. So it's just an alternative pathway.
It really is. This is the thing. The laws haven't changed. This isn't a proposal to change laws. It's just really just another forum, another entry point.
Exactly. And I think employees naturally probably think they go to the Commission for this type of assistance. They go for everything else. And so it's just giving them that avenue. And I expect probably most people will take that path as opposed to going to the Human Rights Commission, which has had a bit of an interesting past with regards to these type of issues.
Do you think it'll be a forum that individuals use, or do you think it's a forum that unions will use for their members?
It's a really good point. Unions themselves can bring an application, and also multiple employees can gather together and they can have their claims considered collectively if there's, some one individual that's caused a bit of, trouble amongst multiple employees, they can band together and have their applications looked at.
Do you think there'll be a lot of these?
Oh, look, it's hard to say. I think culturally the dial is moving. I think the shame that used to exist with the person who made the complaint is very quickly moving to employers. But it'd be very interesting to see whether anyone allows it to be arbitrated at the commission level, or whether we still see, like we do with most things, people say, no, I'll take my chances and take it to the federal court. But I think we might start venturing like we do in unfair dismissals, go away money. Just put it in a claim, settle it, take some cash, and everyone walks away.
I could see some companies, larger companies, accepting arbitration. I could see that.
Yeah, potentially.
Because the scheme of arrangement in the federal court is far more legalistic. I mean,
far more public.
It's far more public. So I could probably see this sort of becoming an avenue which a number of employers might be quite comfortable with.
And a lot less risky, I think, than the Human Rights Commission, and that the people looking at the matter are far more judge-like than you might end up with.
You said that with care.
Very careful, trying to step my way through.
So really a continuation.
Just another
As
avenue.
you said, Lewis, another avenue, another forum, nothing dramatic in terms of rights, though.
No, but I think if you marry that with the fact that we're seeing the Respect at Work legislation imminently going through Parliament and the positive duty that's going to apply, all of that married together could mean that if you don't have your house in order in respect of that stuff, you might end up in the commission to deal with it.
And can you just explain the positive duty? Because I think this is something all employers are going to have to get across. And just talk us through the positive duty generally.
So there's a new positive duty that will be federally at play. For those in Victoria, it already exists. But it will say that employers have to take all reasonable and proportionate steps to eliminate sexual harassment. So the current test is a defence. So it's when a problem happens, I defend myself by saying, no, I did all reasonable steps. I trained everyone. I had a policy. I ticked all the boxes. This says that you can have no complaint at all, and the regulator can still come after you, as they have done in Victoria, for example, to a big bakery company, and they can look into you and say, have you taken all reasonable and proportionate steps, even without any sexual harassment complaint being made? And if you haven't taken all reasonable and proportionate steps, most likely you're going to be forced to enter into a compliance deed. Most likely it's going to be public, and you're going to have around 6-12 months to rectify your behaviour, and everyone's going to know about it.
And I sort of see that step almost moving it into the world that we have WHS.
Absolutely.
It very much is,
It's that type of model.
Risk assessment.
It's sort of improvement notice if you haven't done it. It's not we just wait for an incident or somebody to get hurt.
Yeah.
It's about actually having a system, a scheme of arrangement.
And I think this is the message for employers is you need to move how you respond to this type of area of law to that WHS model. You need to be proactively assessing risk, putting documents in place. And I think
auditing yourself regularly.
Tamsin's working on a whole suite of documents at the moment that we're going to make available to clients and New South Wales Business Chambers members, where you can actually leverage off this documentation to try and put in place a type of regime that will comply with your duty.
And for the industry associations who are watching, just give us a call if you're interested in that, because we'll have a good talk to you as well and how we support you. We got to arbitration. That's interesting. We jumped around. I'm not sure why we jumped around, but that's okay. We'll live that. As Lewis said, it's a brave new world. If you have a bargaining dispute, and if that dispute is perceived to be what is called intractable, which effectively means there's no likelihood of there being a resolution, one moves into a arbitral phase. There's a few preconditions. You've actually had to have gone through what is called the conciliation step in the Fair Work Act. That's section 240. It's always been there. It remains in its current form. I don't see any changes to that. In other words, you've got to have applied to the Commission to have the dispute conciliated first. If there are no reasonable prospects, then we move into this world where effectively the Commission will issue a declaration to that effect. And one of two things applies. The Commission could give you what's called a post-declaration period. That is, I'll give you a month to sort it out before I actually arbitrate. It could do that. Failing that, it's an arbitration. It's basically governed by what's currently in 275
the workplace
determination. 275 workplace determinations. We've got a lot of questions recently about how will those arbitrations be run. It's too complicated to go in today. Come and talk to us. Productivity is a consideration, but it's not a requirement. Effectively, it's, quote, the merits of the case. And that might involve looking at what you've done in the past, what you do elsewhere in your business. It might look at what is done elsewhere in your industry or your sector. So there could be a variety of what we might call comparative fairness examinations in arriving at an arbitration. And it might well be that you arbitrate most of what's in the agreement, or you only arbitrate selected parts and the rest is agreed to. So that's arbitration that's coming through. It doesn't scare me because I grew up in an arbitral world, but for a lot of employers who've never been in an arbitral world, it probably does bother them.
I think it's going to depend on the size of the employer. I think some of our bigger employer clients are going to actually look forward to this because I think there's a lot of historic provisions in some enterprise agreements that might not necessarily pass through the arbitral prism or lens. That is built up over time, prohibitions or restrictions that actually don't fit well with how business runs. They are potentially
and
at
they
risk.
don't have the industrial muscle to win it in the field.
Yes, that's right. You don't have the industrial muscle to win in the field. You could actually do quite well. So for some of our bigger clients, I think there's real opportunity here. It's the smaller businesses that I'm concerned about, the smaller, medium size, where they haven't necessarily had EAs forced upon them. And now if they don't agree to certain terms, unless they have good basis to resist, they might find themselves in this kind of exchange of positions and having to compromise, or else put up a good defence as to why what the union's seeking shouldn't be accepted. So they're the businesses that are going to really need some help through this, but there may be opportunities for our bigger clients.
Yeah, I agree with that. And now arbitration kicks in something else, which is quite dramatic.
Absolutely.
I'm gonna let you have this if that's all right.
Yeah, absolutely. Or flexible work requests.
Yep.
Everyone hopefully already knows they exist. Certain only categories of people.
So the categories stay though, don't they?
Categories currently stay. Currently.
So I'm currently good on you. So I'm caring for a child under 18.
I'm caring for a child. I'm looking after someone who's disabled. I'm over 55. I can apply for a flexible work request.
You looked at me when you said that. That was quite interesting. That was good.
That continues to apply.
Right.
The difference is now you have to genuinely have a discussion with the employee about it. You have to think about alternatives that you might be able to offer. If you give them the letter after 21 days, the same amount of days applies. But in that letter, not only do you have to say, no, I'm not accepting your request because it doesn't suit my business, you also have to put other options on the table if they exist in the letter. And you have to remind them in the letter, wonderfully, that they can also go to the commission to have this reviewed and looked at. And the commission.
So I can still refuse on reasonable business grounds?
Yep.
Okay.
But you have to, I want to make those reasonable business grounds very strong.
Very reasonable.
I'd also, want to also put in there another, generous offer or something slightly different that might work a bit better with your business, because all of this is going to be looked at and considered by the commission when it comes to them arbitrating. And they have basically carte blanche ability to order a very broad range of things that might be saying, well, no, they're not reasonable business grounds and you must allow their flexible work request. Or I see the other thing you put on the table in your letter, we'll give them that. Or they might say, actually, these are reasonable business grounds. What they're asking for doesn't accommodate your business. So it's all lawful and above board here. But it's open to dispute and argument.
This is a kind of Pandora's box that we're opening up here, because we've never been able to arbitrate or debate these reasonable business grounds refusals before. This could be a request to work from home because I've got a school-aged child. The employer might say, look, that just doesn't suit the way I run my business. They could race off and get arbitration, and the commission could look at that and say, well, actually, I'm going to order them to be allowed to work from home 2 days a week. And we're now living in that world.
Yeah, I think there's two key areas. It's going to be changing to working hours, and working from home will be the two big areas.
So starting late, finishing early.
And I think employers, the other big takeout here is employers, when they refuse these requests, they will really need to challenge themselves as to whether they can accommodate it. If they can't, what is the objective information and evidence available to demonstrate why this is not reasonable to accept? You can't just be going off hunches and gut feels. You need to have an objective evidentiary basis that you're going to step forward to demonstrate why this shouldn't be accommodated, and that's then what you're going to run with to defend the arbitration.
And also you need to have thought about other things you can offer. I think that's the thing most people don't do. They say, that's what you've asked for, I'm not going to allow that. Now you need to turn your mind to how else might I be able to accommodate it in a way that works for my business.
And I think those employers, particularly smaller business employers, who might have just gone, that doesn't suit me, that's not going to be defensible going forward. They're really going to have to work much harder on that in terms of why. I agree. It's going to be a big change. It'll be a big change. Another.
Oh, maybe we'll give it to Lewis.
We're going to get Lewis. I fixed it. Your favourite. So given that I lost Kayam 2-1, I should probably do this, but that's okay. Fixed term contracts.
So yeah, the bill.
They're not going, are they?
No, so they're limiting the ability to enter into longer fixed-term arrangements. So the fixed-term contracts can be entered into, but to the extent they go beyond 2 years, that's where they're going to be prohibited. The other thing that you're not allowed to do is enter into contracts that can be renewed more than once. And so you can have a fixed-term contract that gets renewed, but not multiple times.
So can you go longer than 2 years?
No. So the combined effect of any successive contracts also must be less than 2 years. So there's two prohibitions here. One is on fixed-term contracts going for longer than 2 years. The other is on having a contract which is able to be renewed more than once.
And Lou, I haven't looked at this, so this is literally a naive question. Does this apply at large? Because there's a lot of CEOs on 3, 4 and 5 year fixed-term contracts.
There's a number of exemptions to these provisions. I think they're on the next slide. One of them is employees that are above the high income threshold. In fact, we've highlighted that. So if you are on a salary above 162,000 is the current high income threshold, none of this applies. So that's a significant carve out for higher earning individuals. The other interesting one, which I'm not sure goes far enough, is contracts that are wholly or partly funded by government funding. There is an exemption for those to go for more than 2 years, but only where there is no reasonable prospect that the funding will be renewed. And I think the issue there is that for some businesses, there may be a prospect. There may even be a reasonable prospect that the funding will be renewed. I might have held that
3-year government contract for 3 successive periods now.
That's
for 9
right.
years. So.
But there still might not be certainty.
Yeah.
So a lot of clients that we have, particularly in the medical research space, et cetera, that are government funded or grant funded, they may have an expectation of renewal, but no certainty of renewal. And so that's why they use fixed term contracts, because what they don't want is to be up for a financial penalty or redundancy or whatever it is if they have to terminate the engagement at the end of the contract because the funding didn't continue. And I think a number of them won't be able to fit this exemption, which is no reasonable prospects of the funding being renewed. So that's an interesting one. The other, we should call out that apprentice and training contracts are really excluded from this because any training arrangement is exempted. And for many people that will go for 4 years and they're not seeking to interfere with that.
And did Burke flag a few changes on this one as well?
They've flagged a change about a transitional period of this not coming in for 12 months, I believe.
Yeah. So you can get your house in order.
Yeah, but not to the actual categories of exemptions, as far as I understand.
I think what I'd probably say is there are certain industries that have a preference for fixed-term contracts. You named one, medical research. Education would be another, which is quite common, particularly post-secondary. So what I'd just call out to most of our clients, if you're playing a lot with fixed-term contracts, give us a call and we'll have a chat about what we need to do for you, what opportunities there are to maintain your regime or where you need to change it and how you might change it better.
And yeah, the other big call out is that there is for consecutive contracts for genuinely seasonal workers where there's a genuine gap, that will not be caught. So you could have consecutive contracts of 6 months, one after the other for truly seasonal work. But the moment you're talking about education where there's only, a semester off, school holidays off and you're back in, that kind of gap's probably not going to cut it. And so we're talking about genuine seasonal work being okay. But if you're looking at shorter gaps, that's where you may well be caught by these provisions.
Okay. No, I say, if you're in that boat, give us a call because it'll be very particular to your circumstances.
This is you.
Yeah, Nigel has been leading the charge in terms of some of the test cases on gender equity. We've had the equal remuneration case in the childcare sector, equal remuneration case now in aged care. So I think you're well placed to talk about the reforms.
Work value case in nature.
Yes.
Work value case.
Yes, work value case though, but that did have regard to
gender undervaluation.
Gender undervaluation, because these concepts are now linked.
Yeah, and I'll probably just make a few comments. The Fair Work Commission has for quite a while acknowledged that gender-based undervaluation is a legitimate consideration in work value cases, separate to equal remuneration cases. And to date...
Excuse me, I just had some water go down the wrong way.
Do you need some more water?
No, more water won't help, thank you.
Fine. And to date, while there haven't been a lot of equal remuneration cases, apart from the original Shad's case, which was by consent, all of the cases that have come after that have actually failed, largely because they were industry cases run at an industry level. Those cases effectively required a comparison of like-for-like work between genders. They required a comparator of the other gender in that case. So what's changed? Given that we've had that regime operating quite successfully in a way, in the sense of everybody's accepted how it worked. Nobody said in the federal court that it was wrong. It did actually work. These things are being proposed to change. They're proposing to bring in what is called a specialist panel or panels.
Mm-hmm.
There's certainly going to be a pay equity panel they're talking about. Gosh, you only know who's going to be on that. I'll be careful how I say this, but in most of these cases, academic activists in the area tend to be expert witnesses in those cases. I've cross-examined most of them over the last 6 or 7 years. I have a sneaking suspicion they want to put some of those academic activists on the panels. I'm not sure why really. Those people don't have any arbitral or judicial understanding, and frankly, most of their evidence has been broadly accepted in general propositions in cases anyway. But there seems to be this desire to sort of create a panel which pretty much almost will guarantee sort of a particular result, to be honest. The comparative for equal remuneration cases is going. So really those cases are going to be sort of generally run at large around the notion of undervaluation, and it's what a lot of the academics describe as woman's work, and they talk about how it's systemically, sociologically undervalued in our society. I won't get into debate today about whether or not I accept that proposition or not. I think there's something to it, but I don't accept it in the way most of the academics articulate it. I noticed today, Lewis, Justice Ross has handed out a statement describing which industries might actually be female dominated.
That's right, yes.
And therefore subject to gender-based undervaluation. Yep. He named about 7 or 8.
Yeah, quite a long list.
20 awards.
Retail, hospitality.
So if you're interested in that, give us a call. The one thing I will say is that I think the legislation, 2 things. I think the legislation is probably crafted in a way where it implicitly accepts gender-based undervaluation. I suspect we will see a rash of gender-based work value cases now. That was an issue argued in the aged care case in any event that the decision came down a few days ago for. I'm actually a bit disappointed that the comparator equal remuneration issue has gone, because that actually was a genuine way of remediating targeted and direct discrimination in pay between men and women or women and men. And I think that's unfortunate. I think they could have actually kept that. Even if they'd added some other things to it, it would have actually been more meaningful to do that. So look, bottom line is that equal remuneration, gender-based equal remuneration is freed up. And I think what we'll probably see is we will see work value cases with a gender flavour run, particularly childcare will be an example. I spoke to them this morning, but there will be other sectors where those cases will probably be run.
And we've worked obviously with a number of employer organisations in childcare, in aged care, in defending these. So if you're from an employer organisation, you're concerned about your particular sector, just give us a call.
Yeah. Interesting enough, Justice Ross in aged care did actually say something on the record which I thought was very pertinent. He said, if it's undervalued, does it matter why? He said, surely what my job is to make sure it's valued properly.
Yeah.
And I must say, I tend to hold to that view. If something isn't valued properly, then let's just go and value it properly. Although there's obviously a lot of politics around saying it's gender-based these days.
Do you think they will see it in retail and restaurants? And is he foreshadowing for that reason to say it's coming?
So my view is that these cases are very difficult to run. They still will be. You still need to properly assess the work value. Right. They're very large proceedings. And I've just been running the aged care one
for a year.
Okay. So I think you'll see them.
87 lay witnesses cross-examined, 12 professors.
So I don't think we're going to see 5 cases all at once. I think you'll still have this staggering of 1 a year kind of thing for a number of years in a row. But it takes the unions a long time to mobilise to get this all together. And so when they do it, they tend to try and do it as properly as they can. And that involves lots of witnesses. And so there's not going to be 5 equal work value cases in January because the legislation passes in December. Some of these things take time.
And I mean, for me, the intent that's always been behind this is laudable. That is, if you have a man and a woman doing work of comparable value and there's no good reason for why they're paid differently, you need to look at it. And that cuts both ways, whether or not it's a woman to a man or a man to a woman. So, I'm not going to criticise in any sense, never have, what's behind this. Some of the machinery in this, though, is going to be interesting to see how it plays out. Pay secrecy. We had an argument about this before we came on air. You said you'd take it.
I'm happy to take it.
So what can't you do now?
Well, what can't you do soon?
Soon.
Once the bill passes, if you don't have a pay secrecy clause in your contract, you're not going to be able to put one in. If you do have one in your contract, it's going to continue to operate until you vary your contract, which we assume is if you just change someone's pay, you probably vary the contract. So it's going to roll and impact all contracts. If it's in an enterprise agreement, pay secrecy, from the moment the bill passes, it won't be legal. If you have them in your contracts after you varied your contract, it just won't have any effect. But also 6 months later, if you try to put it in a contract, 6 months after the bill passes, it will also be an offence to put these into contracts.
God.
And it's giving employees the right to do two things. One, to ask the question and try and have the discussion, and the other to disclose. Or choose not to disclose if you want to.
So this is that classic clause that says your remuneration is a confidential issue and you're not to tell
You might be
anybody
subject
about
to
it. And
disciplinary action if you were to
I
discuss it.
suspect I could get 7 HR directors in the room. We could have an interesting conversation about this. And I've said this before we came on air. My view is young people tend to ignore these clauses in their contracts anyway. And when they're at the pub, they tell everybody what they earn. Another thing I've said, which I think is true, is from my experience over the years, a lot of people lie about what they earn. Sometimes they lowball it, sometimes they highball it. I'm not actually paranoid about these clauses going, but I think other people are anxious about them. I'm not sure where the three of us sit.
I don't think it's a big deal. I was having a discussion before. Tamsin has, I think, quite rightly pointed out, but before that, for particularly where you have undervalued work or female workers not earning as much, the fact that they don't have visibility on other pay is a matter that may feed into historic lower payments.
Still might not get visibility here.
But this is what I was about to say. This is what I was about to say. I agree with that as a concept, but in my view is I don't know how much visibility is going to change. I think those people who wanted to talk about their pay will talk about it. Those that didn't. Still probably a taboo, kind of socially awkward topic for most people. So I don't think we're going to have this uniform kind of proclamation of someone's pay from the rooftops the moment the legislation gets changed. But it's at least symbolically, it's starting to open up a little bit more transparency, and it may.
I think it will be very interesting in the current market where employees are very short and people are offering a lot of bonuses for people to come on board, higher pay. You might have people who effectively do the same job who could be on quite different pay levels if you've boosted in order to get someone across the line in this current very hot market.
There is timing issues.
Yeah.
Incumbents versus new hires.
Correct. You might have, and it might be just a temporary kind of pain thing, but I think in the current tight market, which will obviously slow down as things in multi-enterprise bargaining occur.
as that drives us into recession.
Yeah, as it drives into recession. But I think if you just look at the last 12, 24 months, we've seen, a huge tightening of the employee market. A lot of people have been throwing a lot on the table to get people across the line. And you could really have discrepancy between, very junior people that perhaps we didn't see in the past that now can openly be discussed.
Yeah. Look, I'm actually quite relaxed about it. The one thing I probably would say is, if you're an employer who has an objective way of determining pay, we do in our business. We have benchmarks, we have criteria. We look at a certain percentile in the market. You're probably going to be fine because you've got defensibility. If you're an employer who just sort of goes, yeah, I like Lewis, I'm going to give him more, that's probably where this might become a challenge to how you're exercising your discretion, particularly if all the Lewises get paid more and all the Tamsins get paid less. But
time will tell.
Time will tell. So let's pay secrecy. Little bit, and we've probably still got ourselves a nice little rump of time just to ask some questions. I've got quite a few. Compliance, Liz?
Yeah, there's not much to unpack here. The ABCC has been abolished. We've all heard that. There will be a national
Australian Building Construction Commission.
Yes,
For those who don't know,
it hasn't gone yet.
It's about to be abolished. So this is kind of the watchdog in the construction industry, which has been quite prominent in bringing a lot of prosecutions against the CFMEU. that they will be abolished. There will still be enforcement activities from the Fair Work Ombudsman, but we're probably expecting a different level of enforcement proactivity than the ABCC had. The Registered Organisations Commission, that continues to exist.
Bothers our employer association clients, but doesn't bother employers per se.
No, and it's going to continue to exist. It's it's moving into the Fair Work Commission.
Which it was originally anyway.
Yes. So there's not much to talk about there. The only other thing is small claims. So currently you can bring a small claim in a much more informal setting, either in a local court or the Federal Circuit Court's kind of small claims jurisdiction up to $20,000.
This is an underpayment claim.
This is an underpayment claim against an employer. That's going to be increased to up to $100,000 claims, which is kind of interesting because $100,000 is kind of not a small claim. These small claims jurisdictions do have far more informal processes. They don't involve lawyers as of right. And so you could have quite a significant claim now being determined.
Is that per employee?
Yes. Oh, actually, that's a good question. Well, I mean, generally each claim would be, each matter would have its own file number, and so it would be per employee. Yeah, I would say so.
And I think it's probably, I mean, it's surprising because the thing that was mooted was actually moving all of that into the Fair Work Commission.
And that may come.
That may come because there are quite a few employers and employer groups who actually were happier that it went into the Fair Work Commission. And then there were some who were very antagonistic about it being in the Fair Work Commission.
I think we've got to remember this is the first wave of reforms.
Yeah.
There's a lot more to come next year. And I think redoing the commission to facilitate small claims, all that stuff might come next year.
So before we get on to questions, I'm just going to, so I've got some doozies on the live feed, but Lewis just said there's more to come next year. There's still a lot of negotiation about this bill. Tamsin, you're more across this than most of us have.
Yeah, we know that they need Jackie Lambie or David Pocock.
And at the moment,
both of them are holding Lambie's definitely out of the table. She's not as open to it.
Pocock's saying,
I need more time. You're rushing me. Let's do it in the new year. Do it in February. Okay. But, you know, everyone can be bought off. And apparently it's the ACT housing debt he wants wiped. So maybe if they put that on the table, it could be done by Christmas. Who knows? All
right. Well, I'm sure. I don't know him at all. He played rugby, didn't he?
Yeah, he was captain, Australian Wallaby.
Well, yeah.
Clearly, obviously, a very good person. And next year at this stage, unless something strange happens, the second tranche of reforms will come through. That's going to be a lot
same job, same pay.
Job, same pay.
Regulation of gig economy.
Regulation of gig economy. And a lot of talk about possibly something to do with transport contractors as well.
Casual definition?
Casual definition will come through next year. So look, it's not, this is big. Next year's could be just as big. And this one's quite audacious, so next year's could be quite audacious as well. So we'll have to wait and see. But stay posted in terms of what final form this takes and when it starts. Questions? All right. Now, in no order of priority. Here we go. You ready? If your organisation does not have union membership, can it be dragged into bargaining? Well, the answer to that is yes, absolutely. You could have a union who exercises a right of entry to hold discussions with members or people eligible to be members. That could foster them getting up there 50% plus one support to rope you into an agreement. So this isn't all determinative on union membership. It might also be the case that a union runs around town saying, join us and you can get 20% pay increase. So it might be a way of marketing to increase union membership as well. This is a beauty. I like this one. Wouldn't a reduction of competition be contrary to the public interest?
Look, the explanatory memorandum talks about this. It does. It actually acknowledges that in some scenarios, that is a factor that may warrant not granting a single employer authorisation. So there is some acknowledgement of that in the explanatory memorandum to the bill. It's going to depend on what that impact is of reduction of competition.
One employer, no. Across an industry, maybe.
And the explanatory memorandum directs specific attention at what is the outcome or effect of that reduction in competition. If the effect of that reduction in competition is going to adversely affect the quality of supply, the way efficiency of the supply, that is relevant. If it's just going to mean they're all paying the same rate, that's going to concern the Commission far less. So the EM is already directing, don't just say, oh, reduce competition, then you shouldn't grant it. What is the effect of that reduction of competition? And if it's not going to affect the quality of supply and it's not going to affect output and all those things, then it might not be a bad thing.
Now, Nesha won't mind me calling her out. Nesha from Australian Childcare Alliance has asked a question. This is a doozy, by the way. Could membership of an association be considered a common interest?
Well, I think, I hope not, Nesha, because I think then you're starting to give common interest extraordinarily broad work to do.
Broad scope.
It talks about clearly identifiable common interests. I would have thought what you're looking at is the business, what drives it, what its operational imperatives are, the environment it works in. If we're all of a sudden going to say membership of the same employer association gives you a common interest, all of a sudden we're talking about very big umbrellas we're putting people under. And I'd be concerned if that's how light it is to get into a common interest.
No, I wouldn't put it past a union to have a go at it. I think what's more relevant, though, is the commonality that those people have because they are members of it.
Yeah. Why are they members of the same?
In the first place, that's good. Really interesting question. Will the introduction of these reforms, will awards as we know them today disappear? Absolutely not.
There's nothing in the bill about awards, though.
No, they're alive and well. And I've said to the team that think of awards as the minima, although possibly for some an increased minima. And think of industry enterprise agreements almost like the new market condition. And then possibly think of individual employer enterprise agreements sort of as sitting separately to that. I think what we're seeing is this sort of added layering to the system. But no, modern awards are not...
It's going to be very hard to hide on them, though.
The whole theory of this is to try and force people into an enterprise agreement to lift their terms and conditions. And as the government said, we're doing this to lift people's pay. It might read a book on inflation in due course, but we'll find out about that. Let me just ask there was a couple here which I just had to ask if I could. Let me just start. Are there any arguments about extending fixed term contracts? Are there any justifiable basis to roll a fixed term contract over for more than 2 years?
Well, there's quite a long list of exceptions. So the short answer to that is yes. And what you might find is that for some businesses they can leverage off that. The other thing you need to remember though is if you're talking about consecutive contracts that are separated by a gap, that they are trying to preserve that as well. So genuine work that arises for 3 or 4 months, goes away, then you have another 3 or 4 months. As long as there's no substantial continuity between them, and we're going to have a lot of arguments about what that phrase means, then you can still have someone who comes in for 3 or 6 months.
So like the Christmas retail sector.
Absolutely.
The snow season.
Yeah, you could have a seasonal snow worker that has fixed term contracts 10 years in a row.
Yeah.
And they're not trying to interfere with that. But, I mean, this is really targeted at employers that are using fixed term contracts as instead of a probationary period and trying to just have people constantly roll over and never get security of employment. That's what it's targeted at.
Very challenging question. What's in this bill for small business?
Well, they're exempt from a few things.
So yeah. There's, and I might start this off myself. Almost nothing. I'm going to be blunt about that. It's a missed opportunity for small business. You've heard me say this now for years about separately regulating small business, a small business code that small business is actually competent to deal with. So there's a complete missed opportunity for small business here. Tamsin, you're right. The best you get is some of this might not apply to you.
A bit of a safe haven. If you can keep yourself under 14.
Keep yourself under 14. Sadly, it's not FTE, but so look, to be frank, no, not a lot. And there's actually quite a bit of downside. Certainly in the supported sector, small business can get scooped up into all of this. So this is not a small business friendly bill, and it really doesn't seem to be targeted at sort of helping and encouraging small business. I think that would be a fair way to describe it. Great question here. Industry bargaining is going to destroy regional labour costs compared to city labour costs. Lewis, we had this argument this morning.
Yeah, I think the industry bargaining, if it is genuinely industry-wide, is going to come up against this challenge that in metro areas, rates of pay are higher, conditions are different to in regional areas. And I think this is going to be a challenge that the Commission needs to direct its attention to. I think it could enliven the public interest points. And I think this is really the role of employer organisations. This is the role of firms that might be representing respondents to multi-employer bargaining, such as our own, to really identify when you have regional areas being caught up, is it actually the case that they are on the same playing field, that they're going to be equally impacted, or are they going to be prejudicially impacted? And if they are prejudicially impacted in a material way, that's disproportionate, that's something that's going to have to be spelled out and explained to the Commission. But it's going to really, we're going to have to wait and see. But without some level of differential treatment, we may see regional businesses really struggle with this form of bargaining.
Will it also impact their supply chains? Because it's likely, isn't this, I think, the farmers' point as to why they're also now opposing the bill, that even if they don't get hit and roped into things, the cost of everything that flows onto them is going to likely go up with the cost of wages in metro areas.
Yeah, and I think I had this debate with Nigel before. The government's being very, very open about the fact it wants wages to go up. So if people, I don't think the whole inflation argument, clearly the government will need to address inflation elsewhere in the economy. It has been very clear since day one.
It hasn't said how it's going to do that. But if you're throwing money at workers, you're throwing money at various sectors. You've got to contract somewhere.
Somewhere else. And that's going to be the challenge the government has to deal with. But it's been very clear it wants wages to go up. And so I think it's going to be difficult for employers to turn around and say, well, this is going to make our costs higher and this is inflationary. That's entirely expected. Yeah. And it's a matter for the government to address inflation elsewhere, and hopefully they do.
I have a review for this one if we can. Parental leave covers, fixed-term contracts for parental leave coverage.
That's an exemption.
That's an exemption. Yep. Good. That's a lovely question. I like that one. Look, I'll just comment on the regional stuff. I've said for years now that the system isn't actually designed to support regional labour markets. You possibly could, I mean, this would be interesting. So we've had some questions about tourism come through as well. You know, you could possibly see the Port Douglas Tourism Group actually talking about putting together the Port Douglas Enterprise Agreement. It could work with the United Workers Union on that. And try and create an agreement that is more supportive of the Port Douglas tourism sector. So it's not all, you know, that you could see opportunities where different sectors could actually try and use this to try and actually create something that supports more regional labour markets, particularly regional labour markets built around things like tourism or particular industries. Certainly in Tasmania and other places I could see that. So it's not, I wouldn't necessarily say it's antagonistic to regional labour markets, but you'd have to work pretty hard to find the benefit for a regional labour market. Oh, okay, that was good. That was good. We've answered that. Great question. Hi, team. Why not just raise award rates rather than create this mess? Jacob, thank you. Thank you for that. Jacob's a client, a good client. Do you have a view about that? I think they're going to be raised anyway.
I think it remains to be seen how industry-wide this bargaining is and how targeted it's going to be. And I think we need to see how this is going to play out, because there's two different kinds of scenarios that can be captured. To be very frank about it, the government, well, not the government, but a number of people who are involved in the bill and who are involved in industrial relations very much have an understanding that much of this is directed at the Qantas scenario. So Qantas has been very successful in outsourcing a number of its cabin crew, its cleaning, its baggage handling. And the idea is to stop outsourcing in an ecosystem like that and to bring them together. That's not industry-wide bargaining. That's not saying Qantas and Virgin and Jets are all going to be on the same.
That could be their broader supply chain.
That's bringing a supply chain together who all service the same plane. Now, if that's the nature, well, we're not talking about changing the whole industry. We're talking about an ecosystem where stuff has been subcontracted out and bringing it back in. And you may see the same in road transport. Coles and Woolies subcontract to Toll, Linfox, others who then subcontract to others. And we may see that some of this subcontracting chain gets brought back in to service the supply chain whole. Now, that's something very different to just upping the rates across a whole industry. It could be, though, particularly with the supported bargaining, you take childcare, you take aged care, that they seek to have an EA for the whole industry. It's possible. We need to see how well organised the unions are. They still need majority of employees in a lot of these workforces. They still need the density to get out there and to hit the ground. And some unions are good at that and some haven't historically been as good at that. So I think it remains to be seen whether this is going to have industry-wide impact or it's going to be more targeted. And if it doesn't have industry-wide impact, then the award may still have work to do.
Will it kill off labour hire, though, if the sole goal is just to make all the wages bang on the same? Think of the mining industry, right?
Well, remember, this isn't the same job, same pay legislation.
No, but it
So
can't.
That's next time.
Yeah.
And there's a lot of stuff regulating same
But do
job,
they
same
need
pay
it?
here.
If
Well,
they're-
they might not.
Yeah.
And that's the use of the multi-employer banding people together. You might find this is quite effective already.
Well,
Remains to be
you could
seen.
have a common interest established at a particular mine site involving everybody involved
Yeah,
at the
that's
mine
right.
site.
All
That would
of
be a
the-
classic common interest argument.
Mm.
There's some old case law from the old days on in or in connection with mine sites, without a doubt. Last question, if I can. We might just have a quick wrap up between the three of us. Impact upon salaried common law contracts generally.
What, pay secrecy clauses?
Well, that's part of it.
That's part of it. Anything other than that?
I think that this probably won't impact hugely on people who are paid above the award safety net. I think what we're seeing a lot of this targeted at is people on award or EAs and having them brought up. And certainly there's going to be an impact where directly there are award workers and enterprise agreement workers, they're going to get a lift in conditions. That's inevitable. I'm not convinced that necessarily will flow out into the common law people paid salaries above award, except for the indirect consequence, obviously, which is when one portion get, by comparison, others might lift. But that's more of an indirect, longer-term impact.
But do you think employees for the first time might look across to other types of businesses that have enterprise agreements that maybe they don't in their business, never have, and say, oh, hang on a second, I want to just be roped in on that?
Well, that's interesting. That's about common law. That's a really interesting point. You're talking about common law salaried employees seeking EA as a different.
Looking across, saying they're getting paid a little bit more, they've got a slightly more flexibility in the way they work. Do I just simply band together with my colleagues and let's rope ourselves in?
Well, there'll be people on the cusp that might impact.
Who have never had an EA before, who've never thought they'd even be in the space of needing to bargain. And they don't have to bargain. They simply get roped on in.
There'll be some balances there. There'll be a question about how enticing that looks.
Mm.
There'll be a question about the culture of the place I work and whether or not it's, I've got an engaged culture and that's consistent with that culture. If I'm working in a place where I feel quite detached and disengaged and there's 30% over the road, then maybe rather than go there to get a job, I start to think about how do I bring their conditions to us. I think that's a possibility.
Yeah.
But
well, just with high inflationary markets, we're not seeing wage growth at the same level. If we start to see big 10, 20, 30% in agreements, it could look very attractive.
I don't disagree.
Yeah.
We'll wait and see.
Look, for all those people whose questions we didn't get to, my apologies. As always, we'll do our best to see if we can answer them through our literature as we send out. 2 minutes left. I warned you I was going to do this. General comments? Good, bad, indifferent? Shocked?
I was...
Could have been written in a way that employers might have been okay with?
Yeah, I think some of the multi-bargaining's gone quite far, and it's going to be interesting to see if it remains as currently drafted, and some of the changes that are being already talked about, as I mentioned, Mr. Burke talking about multi-agreements only being able to be voted upon if the union agrees. Some of that is more adventurous than we expected, and we understood what the campaign platform was going in, but there does appear to be significant reform, and I think it may have, if they've overstepped, if they've overreached, we'll see pretty quickly, there'll be a lot of clamouring about the impact of this and people involuntarily being pulled into processes. And then the only way to get out is to have the union agree to the terms you're putting forward or an arbitration in the commission. It's a lot of compulsion. We're moving from a system of agreement to compulsion. If that worst case scenario outcome arises, we're going to see some blowback, I think.
Tamsin?
I think it's a real change in mindset. I think things that used to be bad, like perhaps getting on the hamster wheel of an EA or going to arbitration, things that historically, or at least during the Fair Work Act life, we've thought of as the bad things to kind of get involved in, now suddenly look far more attractive. And I think if you can get your mind around to lose those old perceptions that we had about things and be very open to things that in the past were very, I suppose, dangerous, there might be a narrow path, but you're going to have to be very on the ball, I think, and very willing to be open to doing things differently.
And I'd probably say not dissimilar things in this sense. It smells a bit like work choices to me. There's half a dozen things that could have been done here differently, which actually almost would have made it, well, okay, we could live with it. And they've kind of gone a bridge too far with some of them. I think the roping in is a classic example of it's going too far. I think the important thing for most of our clients is some of the things which were strategic considerations which drove you to turn left in the last 10 years might now drive you to turn right. And that's the conversation you need to be having with us sooner rather than later, particularly if you are already involved in the union bargaining space. That's a really important consideration. Thanks.
Thank you.
Thanks for coming.
Thank you.
Thanks for coming. Thanks for having us. I told you we did an hour and a half.
Yeah, an hour and a half. I was
Longer.
just checking the time. 1 minute over.
Stay tuned. We'll keep you posted as there are developments and there are changes. We'll send out some more insights as that happens. If it does go through before Christmas, obviously we'll come back and tell people exactly what its final form is. Thank you very much for your attendance today. If you have any questions, give us a call and we'll see what we can do to help you. Take care and please stay safe. They're interesting times. Bye-bye.